Virginia. Today I'm going to talk about bridging the research divide, democratic access to legal knowledge in rural America. And primarily what I want to talk about today are some of the barriers and challenges that attorneys in rural Appalachia, rural America more broadly face when they're conducting any sort of legal research, whether it be research for their clients, more academic style research. It is going to be more anecdotal. It's going to be told a lot from the perspective of my experience as a practicing attorney for 5 years, as Matt said. For about the last 5 years before I joined Appalachian School of Law, I was a criminal defense attorney. In Southwest Virginia, we don't have a public defender's office. So that means that all of the local bar actually serves as the indigent defense counsel for indigent criminal defendants. So just to start off with a concrete example, just so we're all on the same page and kind of in terms of what are some of the legal research questions that you're going to face. So let's say you're a criminal defense attorney, you've been appointed to represent an indigent client who's been charged with burglary. And under Virginia Code Section 18.2-89, these are the elements of burglary. If any person breaks and enters the dwelling house of another in the nighttime with the intent to commit a felony or any larceny therein, he's guilty of burglary. So I think the point that I want to make here, and Matt, because law school typically is Socratic, I'm going to call on an example today. I'll call on our convener. Matt, let's say the statute does not define nighttime, which it doesn't. How would you go about figuring out what that means? Any ideas?
I would would I perhaps look at particular cases? Would I perhaps look at common law? Would I have recourse to that?
Right, that's right. And so in order to actually give content and meaning to these statutory terms, courts are going to interpret these terms in the context of cases. And what's going to result is case law. And so in order for you as a criminal defense attorney to actually defend your client, you're going to have to go and research all of the case law interpreting each of these elements, all right? The challenge that rural attorneys face is that the industry standard legal databases such as Lexis and Westlaw are essential for conducting this task, but they are paywalled. For a single individual attorney, a subscription to Lexis or Westlaw could cost thousands and thousands of dollars a year. For many indigent criminal defense attorneys, that's just simply not a realistic thing to access. There are free and low-cost alternatives, such as I think everyone's familiar with Google Scholar. There's also FastCase, which if you are a member of the Virginia Bar, you have access to. I commend the Virginia Bar for providing that to attorneys, but these databases here lack several critical features, such as number one, comprehensive search. Lexis and Westlaw just simply have more cases. They have a wider variety of unpublished cases, which in Virginia you can still cite for precedential value. So if you go on Google Scholar, there might be a case which could win the case for your client, which you're just not going to have access to because you don't have Lexis or Westlaw. The other thing about Lexis and Westlaw, their algorithmic searches are generally better than FastCase and Google Scholar. You can have more terms and connector searches. You can just be more effective and efficient in your research. The other thing, has anyone actually looked at Lexis or Westlaw before, a legal database? Dr. Prater has, anyone else? Another thing that it has are what are called editorial head notes. And so editors at Lexis and Westlaw go through all the cases, and they will, for instance, categorize all of the cases that interpret the term nighttime. So if you think nighttime is going to be an issue in your case, you can click on these head notes if you have access to Lexis and Westlaw and very quickly see every case that's interpreted the term. And so if you're preparing a defense for your client, you can see why that would be a valuable tool to have access to. These paid tools also have something called shepherdizing. So when you cite a case to a court, you've got to make sure that the case has not been overruled. And so the process of just ensuring that a case is still good law is called shepherdizing. And then finally, we'll talk a little bit more about treatises and forms. Treatises and forms are absolutely vital for rural general practitioners, but they just simply are not available on Google Scholar or Fastcase. And just so everyone knows, in the context of law, a treatise is going to be a book that, if we go back to our elements, just is going to summarize every case in Virginia that interprets the term intent or dwelling house. So it's going to be a uniform centralized source that, as an attorney, you can pull up that treatise and quickly understand all of the cases that have interpreted this element. So nighttime, for instance, in Virginia is defined as 30 minutes before or after civil sunset or sunrise. So if you were a criminal defense attorney and your person was charged in Bristol City Circuit Court, and they were actually, let's just say they broke in 45 minutes before civil sunrise, if you didn't have access to these treatises that summarize these case law, you may miss that case and potentially your client becomes wrongly convicted, because the judge is generally not going to do the research for you. It's up to you as the criminal defense attorney to present the case. Does that make sense to everybody? The other thing that sort of underscores this disparity is that prosecutors' office, Commonwealth attorneys, they typically do have access to Lexis and Westlaw. And so this disparity in research capability can potentially result in disparities in case outcomes. So this is particularly a problem in rural Virginia, just because of the nature of what rural practitioners are going to be asked to do. So Virginia is one of 3 states with over 60 legal deserts. And a legal desert is defined by the American Bar Association as a county that has fewer than 1 lawyer per 1,000 residents. So Virginia is one of only 3 states with over 60 of these. I think the other state is Texas, a geographically massive state. Can't remember the third right now. And outside of our urban centers in Virginia, there's only about 3,600 lawyers who serve the rest of vast rural populations. So let's look at a map right here. So 1 dot signifies 10 attorneys. You can see here, if anyone's familiar with Virginia, this is our state capital, Richmond. There's a high density of attorneys right here. The Virginia Beach area, a lot of attorneys. If you live in the Northern Virginia, Washington, D.C. area, it's almost, you can hardly turn around without bumping into an attorney up there. But you can see there's vast swaths of the state where there are very few attorneys at all. You can notice Highland County right here, at one point, did not have a single attorney in the entire county. And if you look at West Virginia, again, vast swaths of legal desert. So we're located right here, this T-shirt shaped county. This is Smith County. This is where all of the conveners are from. I think, Cody, you're not from Smith County, right? You're from Smith County. So we're all from Smith County. You can notice here, Southwest Virginia actually is a little bit better than Central or South Central Virginia, because the Appalachian School of Law, which is located right here, has significantly helped the legal desert in Southwest Virginia. Prior to its existence, this would have been much more sparse in terms of the number of legal practitioners in the area. But so what's a result of the fact that, for instance, in Bland County, there's no attorneys? You know, I guess what kind of results from the fact that in Smith County, a county of a little over 30,000 people, there's about 1 attorney for every 1,000 people. And so the reality is, for these attorneys, they are asked to be what are called generalists, all right? And a generalist attorney just means that you don't specialize in any particular type of law. Instead, you're going to be asked to do really whatever the client walks in and asks you to do on that given day. So on Monday, you might be defending a defendant charged with burglary. On Tuesday, you might be in JDR court in a child custody matter. On Wednesday, you might be drafting a business contract or putting together a 501c3 for a client. On Thursday, you might be writing a will or a deed. And as we've seen, all of these areas of law are going to have their own statutes. They're going to have their own body of case law, attached to it. And so for a rural generalist attorney, without access to these databases, I guess, how do you really expect them to do a quality job for their clients? Yes.
What happens if you also guilt yourself in small town public office?
If you do that, we'll talk about that in a minute. At that point, you become a policymaker for your community. And I think the point that Matt's getting at, many attorneys in these rural areas often serve on town council or board of supervisors, school boards, those kind of things. So there's a lot of research to be done. And this is where I want to bring it back to treatises and forms. So if you are a generalist attorney, one day you're asked to defend a burglary charge, the next day you're trying to draft a will or a deed, the only way for you realistically to be able to provide for your client without committing malpractice is you really need these kind of databases and these treatises. It's the only real cost-effective, time-effective way to be able to do it. And forms in particular, if you're not familiar, Lexis and Westlaw provide a number of forms which are put together based on legal research. Attorneys will research the cases and put together, for example, sample deeds or sample wills that conform to the statute, conform to the case law. And if you don't have access to those, you either have to put them together yourself, which risks, again, potentially errors or client harm, or more likely what most attorneys do is if someone comes in with something that they just don't have time to research or they just can't put it together, they're going to decline the representation entirely. So if you find yourself in Wise County or Tazewell County, oftentimes you won't be able to find an attorney who can handle your matter just simply because they don't have the time or they don't feel that they can competently provide the representation because they don't have access to the legal tools. So one piece of advice that you often hear is, well, why don't you just use a law library? Why don't you go to a law library that has Lexis or Westlaw? And in rural Appalachia, the advice to use a law library generally falls flat. Number one, the libraries are few and far between. Many counties have none. The law libraries typically have limited hours. They're generally only open when the courts are open. So that means you're not going to be able to go on the weekend when you might actually have time, when you don't have to be in court. And also many of the law libraries that I'm in, they're better than nothing, but they have minimal resources. Many have no database subscriptions. They may have outdated books. So here's a map of law libraries in Virginia. You can see that the Virginia Beach area, plenty of law libraries there. Richmond has a few. Northern Virginia has several. Southwest of Roanoke, we have 2 law libraries within a fairly short vicinity of each other. And if anyone's familiar with Southwest Virginia, if you're located in, let's just say Tazewell to get to Abingdon, although it looks like a fairly short distance, is quite a long drive. There's not many, because of the mountains, there's not many straight lines between places. So this advice to just use a law library, again, for rural attorneys is not going to be practical. The other problem is riding the circuit, so I just want to give a kind of a glimpse into the daily life of a rural practitioner. So a typical day, you're going to be driving from court to court. That's going to be hours of driving. You've got your court appearances, your client meetings. So when would attorneys even have time to drive to these distant libraries if they did exist? So I think this is the key point for anyone involved in negotiating licenses for your university libraries or know someone. Really, research needs to be remotely accessible to fit these realistic schedules. And currently, it's just not remotely available in Southwest Virginia. So this is an example of a typical day for an attorney. So let's say they start in Tazewell. They might have to be in Smith General District Court for a criminal matter at 9 a.m. So they drive across the mountain. Then they've got to be in Washington County JDR at 10:30 for a civil custody matter. They go across the mountain again to go to Lebanon, where they've got a criminal matter at 1:30. And then finally, they're back to Tazewell County for court at 3:30. So you can see right here, 2 hours and 48 minutes in the car, 123 miles traveled. This is a fairly typical day for a rural attorney. So you can also see just the geographic distance between courthouses really compresses their schedule, and they don't have a lot of time to do research if they did. So for the general public, we'll just talk about this briefly. There's even greater barriers. They have fewer access than attorneys. They don't have access to fast case because they're not members of the Virginia bar. They face the same geographic and travel barriers. And courthouse law libraries, if you've ever been as a non-attorney, are very restrictive, very unfriendly. You can't bring in cell phones, you can't bring in food or water. So it's not really a place you want to go and spend hours, researching. So beyond legal practice, many attorneys are also blocked from actually getting academic research. And I have here a few examples of why an attorney might need academic research. So number one, they might need social science research on the credibility of an eyewitness testimony to make an argument for exclusion to the court. They might need empirical studies, for example, the acquittal rate when courts exercise their discretion to appoint an investigator. Courts generally have discretion whether to appoint an investigator or an eyewitness, and you often need to make an argument explaining to the court why you need one. Sometimes they want these empirical studies, and attorneys are going to have a very difficult job getting this. And again, if you're not connected to an institution, you know the difficulties in trying to access academic research. Hein Online, JSTOR, unless you're affiliated with an institution, it's going to be very difficult for you to access those resources. So I think the point today that I want to make is the illusion of access when it comes to law. So it's true that the law is technically available online, but it's not meaningfully usable because you don't have access to these industry standard databases. And again, I have a slide here that's what is democratic access anyway. The way that I define it is democratic access exists in an area when legal information is both freely available and usable by all, regardless of location, financial status, or institutional affiliation. So I think hopefully today in Southwest Virginia and rural Appalachia more generally, hope you've seen the laws are online and technically available, but for most people, even many rural practitioners, they are not really meaningfully usable. So one promising example is Washington County Public Library in Virginia has last year started offering remote access to LexisNexis for attorneys. It's limited access. It doesn't have access to treatises or forms, but it at least is better than nothing. So bridging the research divide, where do we go from here? This is one of these presentations where I come in and lay out a problem, but I don't have any solutions. So if, hopefully we can start a dialogue about potentially coming up with ideas to allow attorneys and public more generally to access these treatises, these legal databases. One potential solution, although it may not be very realistic, there's typically many more universities and colleges than there are libraries. The problem is, due to licensing agreements and licensing restrictions, they will typically not allow off-campus access to non-affiliated members. If you're not a member of the university, you generally cannot access it remotely. So from a university perspective, this might be an area to look at. Again, it would probably be expensive, which universities don't like expensive. It's just not realistic. But I wish I had a map today about the number of universities and colleges compared to the number of law libraries. There's many more, and that might be potentially an option. So, that's all I've got. Any questions? Yeah.
So you were talking about the universities. Do you think it would be practical, like if the university got a license for these databases, and then divide that cost amongst the individual attorneys? Because I mean I don't know.
Right.
You said thousands of dollars. I don't know how much we're talking here, but I mean it would be cheaper to pay for a group license.
Right, and that would potentially be an option. Westlaw and Lexus have this sort of devious thing where they tend to charge based on the number of attorneys who are going to be using the service. And so they actually don't publicly advertise their prices. If you want to know how much Lexus and Westlaw cost, you've got to call them. They'll kind of audit your practice and then give you a price based on that. So Lexus and Westlaw to some extent are part of the issue here.
So is it hard, like for people in legal deserts, like is it also harder for them to find paralegals to assist them with their research?
A lot do have paralegals. The problem is a lot of the people in Southwest Virginia are going to be providing indigent legal defense, which the court-appointed fees for that are just so low that most attorneys can only afford to have someone who generally doubles as both a paralegal and an office assistant and a clerk. So they generally are going to be bound to the actual office itself because they've got to answer phones, when people come in. So one potential solution, if you could afford it, could potentially be to send your paralegal to a law library. But for most attorneys in Southwest Virginia, just financially, it's not generally feasible.
Okay.
Yeah.
I know there's an organization in Kentucky called Apple Red.
Called what?
Apple Red.
Apple Red?
Yeah,
Okay.
it's like a nonprofit. It's founded by some attorneys there. They provide like free legal services, legal education. It's funded by grants and donors in Eastern Kentucky. Is there anything similar in Southwestern Virginia to that?
Not that I'm aware of. There's legal aid offices in Southwest Virginia, which is funded by the state, which provides more specific services to low-income individuals, like restraining orders, certain divorce cases, that kind of thing. But no, I'm not aware of anything in Southwest Virginia similar to Allred. So, yeah.
So we've got about 30 minutes, Ryan. Is it okay for that Cody go and
Yeah.
questions?
Yep.
We can circle back.
All right, thank you, guys.